Joining us now are attorneys and lobbyists, Steve and Amy Bresnan. They are the attorneys who originally wrote the petition to the Texas Medical Board. It sparked this entire rule change, and I'll preface that both of you were not lobbying on behalf of a specific client when you wrote this petition to the Texas Medical Board, asking them to clarify when doctors could provide an abortion to women under the medical exceptions clause. So first and foremost, I just kind of want to highlight, what was your original goal when you filed this petition, and do you feel like you got anywhere near that goal?
So our original goal was to obviously make the situation better with whatever tools we had at the time, because the legislature is not going to be in session until January. The Texas Medical Board was really the only avenue to seek immediate relief for women who find themselves in this situation. So we wanted to make sure that any improvements could happen immediately with the Texas Medical Board. That was our original goal. Where do we think that we are now? There have been some slight improvements. However, we are disappointed. We don't think that doctors will feel any more comfortable providing abortion care where it's necessary under the statute, which means that women are they're not as safe as they were before or after these rules were adopted. Basically, the Texas Medical Board had an opportunity to codify two very important Texas Supreme Court cases. One is the Kate Cox opinion, which was the inspiration behind our petitioning the medical board in the first place. We felt that the court laid out some specific elements that the medical board should basically codify into their rules. And then there was the Zawrowski opinion. What has turned out is that the medical board has only codified one element, and that is of the Kate Cox opinion, that death need not be imminent for an abortion to be legal under the statute. So we've walked out of this with only one element of these two very important Supreme Court cases. That is disappointing. Steve, do you?
Sure. Well, I think that's well said. The Zawrowski opinion in particular set a very high standard that the state has to prove in order to punish a doctor who performs an abortion. And it's basically that no other reasonable physician would have arrived at the conclusion that the woman's life was threatened. That's an extremely high standard. But the medical board today, through its comments, indicated that it's treating these like any other garden variety medical malpractice claim. It's not. And they had a chance to incorporate the Zawrowski opinion in their rules and declined to do so.
And to be clear, what the holding in those Supreme Court opinions is law. Just as the Texas Medical Board rules are also a form of law. So they've created more confusion by having their rules not align
with the Supreme Court decisions and rulings.
Sure.
You said that there were some wins out of this. What do you see as the biggest progress from the new guidance issued by the board?
Well, I think it was an important step for the Texas Medical Board to recognize that the legislature has updated and modernized its definition of ectopic pregnancy. And that definition is found in Chapter 74 of the Civil Practices and Remedies Code. And it's important that doctors recognize the most up-to-date definition of ectopic pregnancy. So that was a win.
It seemed at its core, and we heard from physicians who were coming to the various medical board meetings about this, that physicians are afraid of getting sued. They're afraid of losing their license. They're afraid that, maybe in the moment they thought that this was the right decision to make, but that someone is going to come and sue them under Senate Bill 8. Do you think that fear amongst physicians is still going to be present even with this new guidance,
Yes.
saying the harm's not imminent?
I
Yes.
think. Undoubtedly, this does not move the needle that much on any front. So it's a great concern. We're still very concerned.
Pushback that we have heard from Republican lawmakers who wrote these laws in the first place was physicians should be performing abortions and have the ability to perform abortions when there is a threat to the mother's life. They have said that the law is clear and that those physicians should be sued for medical malpractice. Do you see that as, what is your response to that, I should say?
Well, that's an easy thing to say when in the case of a performance of an abortion, you could go to the penitentiary for 99 years and be fined a minimum of $100,000 and lose your medical license. A regular medical malpractice claim, you could lose your license and you might end up paying damages in a civil lawsuit, but you're not going to the penitentiary for 99 years. So well, you have to take care of the realities of it and the people who are actually making themselves available to provide services out there, but not when there's draconian punishments involved.
That's an important point, because the 1925 abortion law in Texas, I think, was 3 to 5 years in prison, and I don't understand the policy rationale for 100 years later, the punishment being 99 years in prison versus 2 to 5 years in prison or 3 to 5 years in prison.
But that's why this law has to be very, very clear. If it's not, inevitably there are going to be women who need care that don't get it unless they leave the state, assuming that they can afford to do that.
Now, I want to talk about the documentation provision. Of course, now doctors, after performing an emergency medical abortion, will have 7 days to, fill out this documentation explaining the reasons for that and, what they thought, why it was justified. However, one of the controversial provisions that was kind of being discussed during all of these board meetings, Steve, you found was still in there somehow.
Yes. It was a documentation provision under the proposed rules that would have required the physician to document whether there was time to transfer to a, quote, higher level of care in order to avoid an abortion. None of that appears in the statute. It has nothing to do with the abortion exceptions. They took that out of the documentation part and put it over into the part where what a disciplinary panel should consider. At the meeting, they said they had taken it out, but it's over now. It's in the disciplinary part. That's an upgraded, if you will, standard. It's a lot less of a being implied as it is being made more substantive and direct. That's moving backwards.
So hypothetically, if a doctor performs an emergency medical abortion, they could later, once that is being reviewed by the board, be punished if they did not seek out a second opinion from another doctor and seek to transfer that patient to another hospital or physician. Is that correct?
That's correct. And the statute gives to the physician, and this is the Zorowski opinion again, that it's that physician's determination. If no other physician would have done that, that's the burden of the state to prove that. That's a very high burden. We have to protect that on behalf of physicians, and the board has not done that.
And are there concerns at all within the medical community that this documentation that they fill out could be used against them by, the so-called bounty hunters who are suing physicians, going after people who perform abortions in the state of Texas that they think is done illegally?
Well, I'm sure people will be concerned about that. Those records are supposed to be private under federal law. They'd be made available to the agency in response to a complaint. Truth be, physicians need to document what they're doing with patients, all along the way. I think the board was trying to more standardize that along the lines of other medical procedures now. And so that's the concern. They sort of watered down that part on the documentation, but they moved this transfer provision over into a more substantive provision.
What does the path forward now look like for you?
Well, it's a long dark road for doctors and women, and for families who are wanting to grow their families and have more children. We are considering petitioning the medical board with regard to rebuttable presumption language, which would basically codify Zerwowski, which of course we think should be in the rules that were adopted today. Do you want to talk more about it?
We're also consulting lawyers who work actively in the administrative procedures law as to whether the law requires this rule to be republished. So there'd be more public comment on it.
We do think that this rule is required under statute to be republished because there were substantial changes. And under statute, that means that they have to give the public notice and seek comment.
Like the disciplinary part that you mentioned.
Yes.
Yes, that would be one thing. The imminent, not required to be imminent. One of the good things they did was said she doesn't have to be at death's immediate door. And so, you know, that'll give physicians a little more space to operate in. But we think that those things combined are substantive enough changes. The public got no notice that this transfer provision was going to be made more substantive and less just a matter of documentation.
The public needs to be aware of this provision and that it has been upgraded, so to speak, with regard to this issue.
It's important that we not talk about that in esoteric, you know, legal terms either. This means delay. If the physician has to find through any means necessary where a higher level of care, whatever that means, might be, and then get her there by life flight, by car, by train, by whatever, you're talking about delay. Somebody with a life-threatening condition who's already met the standards of the statute then has to wait
In order to
while this physician tries to meet this implied duty. It's a serious matter that has practical application for patients.
And based on what some of the stakeholders have written over the years, it's clear that the transfer provision says in order to avoid an abortion to a higher level of care. In normal speak, what that means is it's going to cost more. So they're going to transfer a woman to a higher level of care, keep her on antibiotics, bed rest until her pregnancy is far enough along that they can perform a C-section on a non-viable fetus, which is extraordinarily more expensive than an abortion in that situation.
We're very concerned that what Amy's describing would be a logical result. Also in rural areas or maybe not in an immediate metropolitan area, the doctor may think, well, in order to meet this standard, or at least to be safe, I'm going to send her, you know, to a medical center in Houston or whatever.
Or San Antonio.
So they've dumped the decision on another, they've dumped the patient physically, and they've dumped the decision on another healthcare provider. When those incentives are in place like that, it's a dangerous thing for patients. It puts the law between the patient and the physician, which we should all try to avoid.
And when you have 100 years in prison, your medical license on the line, what would you do? Would you pass the patient? Maybe.
All right. That's our time for now. Amy and Steve Bresnan, thank you so much for your time today. Appreciate it.
Okay, thank you.